last week's class, we went over the law of restoration. We went through all the articles and did several definitions. And if you didn't catch that, go ahead and go back and familiarize yourself with that before you jump into this. This lesson is going to be on state accessions to treaties. And accession documents are basically an addendum to your Constitution. So addendum meaning those things that you agree to in addition to the Constitution that your state put on the record. So if you wanted to ratify or promulgate your documents with the United Nations, there are a number of accession documents that you need to, as a state, agree to. And we're going to go over the terms of those conditions in this reading today. So we're going to start off with Mr. Mr's going to start from the top. State accessions to a treaty.
State accessions to a treaty is the process by which a state formally agrees to be bound by the terms of a treaty that it has not previously signed. Once a state has acceded to a treaty, it becomes a full-fledged party to the treaty and is legally bound to comply with its provisions. This can have significant implications for the state's domestic and international legal obligations and rights, as well as for the other states that are parties to the treaty. Accession can also be an important tool for the expansion and strengthening of the treaty regime. Accession treaties are important for a newly formed state because they establish the terms and conditions under which the state will join an international organization such as the United Nations. These treaties often include commitments to abide by the organization's rules and regulations and any financial or other obligations that the new state must assume as a member. Additionally, accession treaties can serve as a means for the new state to gain recognition and legitimacy on the international stage. The penalty for violation of treaty accession can vary depending on the specific treaty and the nature of the violation. In general, the consequences for violation of a treaty can include both legal and political repercussions. From a legal perspective, if a state party to a treaty violates its obligations under the treaty, other state parties may be able to bring a claim against the violating state in an international court or tribunal. The outcome of such a claim may include an order for the violating state to cease its violations, as well as the imposition of monetary damages or other remedies. From a political perspective, a state that violates a treaty may face diplomatic repercussions from other states. This can include the imposition of economic sanctions, the suspension of the suspension of diplomatic relations, or the initiation of military action. Additionally, a state that violates a treaty may also face condemnation by the international community and damage to its reputation. It's worth noting that some treaties may have their own enforcement mechanisms, such as the International Court of Justice, ICJ, or the International Criminal Court, the United Nations Security Council, or other international or regional organizations.
Our website home, Allodium, Moorish, Paradis, Monte, Colorado. And you can find it on your browser at gov-ampac.org. So gov-ampac.org. This is our homepage, the splash page, and what we're going to go to is accession documents at the top of the menu bar, and we're going to read through there. I'm going to have Brother Owen take over the reading.
Accession contracts. The supreme law of our state is the AMPAC law of restoration, along with the treaties acceded to or which shall be entered into under the AMPAC flag and seal. A treaty is a contract, agreement, or other international accord accepted by the parties. For the sake of erudition, a few terms require definition. Treaty, accession, accede, charter, and contract. Treaty, a compact made between two or more independent nations with a view to the public welfare. HCBLD, 4th edition, page 1673. An agreement, league, or contract between two or more nations or sovereigns formally signed by commissioners, properly authorized and solemnly ratified by the several foreign sovereign or the supreme power of each state. HCBLD 4th edition, page 1674. Accession, international law, the absolute or conditional acceptance by one or several states of a treaty already concluded between other sovereigns. Merle report, it may be of two kinds. First, the formal entrance of a third state into a treaty so that such state
becomes a party to
it. And this can only be with the consent of the original parties. Second, a state may accede to a treaty between other states solely for the purpose of guarantee, in which case, though a party is affected by the treaty, only by a guarantee, as a guarantor, a guarantor.
Yes.
Accession, the absolute or conditional acceptance by one or several states of a treaty already concluded between other sovereigns. Okay. So in understanding this term, accession, our real life example is we put our Constitution on the record, right? And through all the paperwork that we've done, through all the work that we've done to establish our government, we've then tried to put that on the record with the Secretary General of the United Nations. As a condition, they need us to accede to all the treaties, declarations, and conventions that all the other states have already acceded to. So what is that saying? We want you to be on the same level playing field.
Mm-hmm.
So it's incumbent upon us to understand that what we're doing, that we're making an addendum to our Constitution by making ourselves a party to, and I think we've got several different examples here, and we'll do that as we scroll down. But we're giving ourselves a longer list of rules to abide by. Okay? And then...
and basically, it's just showing everybody is in agreement.
Absolutely.
Yeah.
Absolutely. Mister, if you want to continue with the seat.
Accede, Introduction, Volume 1. To give one's assent, to consent, agree, use with to arrive at or come into an office of dignity, use with to become a party to an agreement or a treaty, use with to, AHDEL 1978, page 7. Charter is an instrument emanating from the sovereign power in the nature of a grant, either to the whole nation or to a class or portion of the people, or to a colony or dependency, and ensuring to them certain rights, liberties, or powers. Such was the Great Charter or Magna Charta, and such also were the charters granted to certain of the English colonies in America. HCBLD, 4th edition, page 298. Contract, a promissory agreement between two or more persons that creates, modifies, or destroys a legal relation. An agreement upon sufficient consideration to do or not to do a particular thing. An agreement between two or more parties, preliminary step in making of which is offered by one and acceptance by other, in which minds of parties meet and concur in understanding of terms. ACBLD 4th edition, page 394.
Pause there. Contract. A promissory agreement between two or more persons that creates, modifies, or destroys a legal relation. An agreement upon sufficient consideration to do or not to do a particular thing. An agreement between two or more parties, preliminary step in making of which is offered by one and acceptance by the other, in which minds of parties meet and concur, which is agree, in understanding of terms. So, preliminary step. So as AMPAC, we took the preliminary step of acceding to the treaties, declarations, and conventions that were presented by the United Nations, and we're waiting on them to accept our offer. But now it's incumbent upon us to keep the rules, regulation, and guidelines of not only our Constitution, but all the acceded to documents, right?
Mm-hmm.
So we can't make up our own rules. We can't say, well, we acceded to it, but we don't really see it as valid, so we're not gonna abide by that particular one. What that does is it takes you out of consideration, because the whole purpose of this is to get international recognition, right? So it's not just we want to form a state, but we're asking for international recognition so that we can get a claim to present to the International Court of Justice to get our state back. That's the whole purpose of this thing, right? We as a organized juror society have met as a government and agreed with the terms of the contract. And as a consequence, you put that on the record with the Secretary General of the United Nations and an application for acceptance to that international body.
The contracts listed herein have been acceded to and are for your study and reference. They are the law of the state, and we are organizing the AMPAC government to be in alignment and compliance with these contracts, treaties, conventions, declarations, and the Charter of the United States.
United Nations.
Oh, United Nations. AMPAC has submitted accession and acceptance documents for each contract shown through the United Nations Office of Legal Affairs treaty section. Each contract listed is accompanied by a link which will take you to the text of the document for your further study and reference. Enjoy the journey.
So these are all the accession documents. 1786, Treaty of Peace and Friendship, Morocco. 1795, Peace of the Amity, Algeria. 1796, Peace of Treaty of Peace and Friendship, Tripoli.
Chipotle.
1797, Treaty of Peace and Friendship, signed in Tunis. 1805, Treaty of Peace and Amity, signed in Tripoli. 1805, Treaty of Peace, signed in Algiers. 1816, Treaty of Peace and Amity, signed in Algiers. 1824, Tunis Convention, amending the Treaty of August 1797 and March 26, 1799. The 1836 Treaty of Peace and Friendship, signed in Morocco. The 1856 General Treaty of Peace between Great Britain and the Sultan of Morocco. The 1880 Treaty of Madrid, right of protection in Morocco. The 1906 General Act of Algeciras Conference relating to the affairs of Morocco. The 1919 International Labor Organization's Constitution with 7 amendments dated through 2015. The 1945 Charter of the United Nations. The 1948 Universal Declaration on Human Rights. The 1948 Convention on the Prevention of Punishment of the Crime of Genocide. The 1960 Declaration on the Granting of Independence to Colonial Countries and Peoples, General Assembly Resolution 1514. The 1960 Vienna Convention on Diplomatic Relations. The 1961 Optional Protocol to the Vienna Convention on the Diplomatic Relations concerning the compulsory settlement of disputes. The 1961 Optional Protocol to the Vienna Convention on Diplomatic Relations concerning acquisition of nationality. The 1963 Vienna Convention on Consular Relations. The 1963 Optional Protocol to the Vienna Convention on Consular Relations concerning acquisition of nationality. The 1966 International Convention on the Elimination of All Forms of Racial Discrimination. The 1975 Vienna Convention on the Representation of States and their relations with international organizations of a universal character. The 1983 Vienna Convention on Succession of States and Respect of State Property, Archives, and Debts. The 1984 Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatments or Punishments. The 1992 Amendment to Article 8 of the International Convention on the Elimination of All Forms of Racial Discrimination. The 1966 International Convention on Civil and Political Rights. The 1966 Optional Protocol to the International Covenant on Civil and Political Rights. The 1966 International Covenant on Economic, Social, and Cultural Rights. The 1969 Convention on the Law of Treaties. The 1978 International Court of Justice Rules of the Court. The 1979 Convention on the Elimination of All Forms of Discrimination Against Women. The 1995 Amendment to Article 20, Paragraph 1 of the Convention on the Elimination of All Forms of Discrimination Against Women. The 1999 Optional Protocol to the Convention on the Elimination of All Forms of Discrimination Against Women. The 1989 Convention on the Rights of the Child. The 2001 Responsibility of States for International Wrongful Acts. 2003 United Nations Convention Against Corruption. 2004 United Nations Convention on Jurisdictional Immunities of States and Their Property. 2007 United Nations Declarations on the Rights of Indigenous Peoples. And that concludes that list. So it's a pretty long list, right? And I didn't count, but let's just say for the sake of argument, there are 25 treaties, declarations, and conventions, right?
True.
Just for the sake of argument. 1979 International Court of Justice Rules of the Court. Let's say there's an arbitrary rule in there that we're not aware of, right? Rules of the court. And we violate that rule. Are we held accountable?
Ignorance to the law.
Ignorance of the law is no excuse,
No.
right?
Right.
1999 Optional Protocol to the Convention on the Elimination of All Forms of Discrimination Against Women. Can we discriminate against the women in our state and be in line with this declaration?
Nope.
And seek international recognition?
No.
We're not afforded that. We can't break laws.
No.
Because these, in addition to our state constitution, are the laws we have to regulate our actions by. And it's not optional. So they're going to look at us as a state, go through our paperwork, and say, is there anything here that gives us the impression that they didn't abide by all these things? And if they didn't, then we can't even consider them as a non-member state because it goes against our rules and the rest of the international community who is already abiding by these rules. So as a newly formed state, we've got to be hyper vigilant about our actions because we can't miss that.
Yeah.
One of the things that I've always preached as Wazir was the doctrine of clean hands is what we're going to read next. So this is from the Cornell Library. Brother Owen Bay, read the doctrine, law of clean hands.
Clean hands doctrine. The clean hands doctrine is based on the maxim of equity, which states that one who comes into equity must come with clean hands. This doctrine requires the court to deny equitable relief to a party who has violated good faith with respect to the subject of the claim.
Okay, stop there. The clean hands doctrine is based on a maxim of equity, which states that one who comes into equity must come with clean hands. This doctrine requires the court to deny equitable relief to a party who has violated good faith with respect to the subject of the claim. Now, for our purposes, let's put this into context. This doctrine requires that the court, so the International Court of Justice, to deny our equitable relief, which is what?
Gaining our
Return of the state.
Yeah.
This doctrine requires that the International Court of Justice deny our equitable relief claim to the return of our estate to a party, which would be
United States.
No, our state, because we're the ones that made the application, right?
Right.
Okay. To a party, a state who has violated the good faith with respect to the subject of the claim. So, what's the good faith?
Man, common law, man. For me, divine's law, common law, common sense.
Okay. So in good faith, we made an application to the United Nations for non-member status. And in good faith, we said that we would accede to all the treaties, declarations, and conventions, right? As an addendum to our state constitution.
Right.
So we violated the good faith of that contract, of our application. with respect to the subject of the claim, which is the return of our estate. So our hands have to be clean in all respects. There can never be even the implication of wrongdoing on our part, because this is our court of resort. This is who we're applying to for relief. And if we can't get the International Court of Justice to see our claim, to hear our claim, then we're without standing as a state. Does this make sense? So we're going to revert back to last week's lesson, Law of Restoration, Article 6, Supremacy Clause. And we're going to go over that because it ties into the accession argument. Mister, if you would do us the honors of reading Article 6, Supremacy Clause.
Okay. Article 6, Supremacy Clause. The supreme law of the land is this law of restoration, as well as all treaties made or which shall be made under our national seal and flag. Our delegation of authority for establishing this law of restoration are the Great Law of Peace, from what is today known as the Iroquois Confederacy, the Treaty of Peace and Friendship between the United States and the Sultan of Morocco, 1786 and 87, as well as 1836. The who?
The J Treaty.
Who's that?
John Jay.
Who's that?
We'll talk about it, but go ahead.
Okay. The J Treaty, the Treaty of Amity, commerce and navigation between Great Britain and the United States, 1794. The Treaty of Peace and Friendship between the United States and the Bay and the subjects of Tripoli and Barbary, 1797. General Treaty between Great Britain and Morocco, the Empire, signed in English and Arabic languages at Tangier, December 9th, 1856. Right of Protection in Morocco, July 3rd, 1880. General Act of the International Conference of Algiers, April 7th, 1906. Charter of the United Nations, 1945. Vienna Convention on Diplomatic Relations, 1961. The Vienna Convention on Consular Relations, 1963. The Vienna Convention on the Law of Treaties, May 23rd, 1969, April 24th, 1970, and entered into force on January 27th, 1980. And for general reference and support, the Universal Declaration of Human Rights, United Nations Declaration of the Rights of the Child, United Nations Declaration, on the Rights of Indigenous Peoples, Indigenous People, the Law of Nations, Universal Just Sanguine claim of self-determination, and the Allodium right to establish our own cultural, social, economic, political, and civilized society on our own land. The provincial government and all Moorish nationals therein shall stand upon the 5 points of light, of love, truth, peace, freedom, and justice. We are
the
autochthonous, Aboriginal, and
indigenous
people within our dominions here in the Empire of Morocco, northwest of Mexico, northwest, and the North Gate shall remain true to the ideals of the law and jurisprudence herein reflected.
Okay. So as you can see, Article 6 ties directly into the accession. And this is in the body of the Constitution. So the author of our Constitution, Gabonde Wasebe, had already started provisions before the accessions. He knew that there were steps that had to be taken to get us recognized by the international community. So we built it into the law of restoration itself, Article 6. And it's really just a short list because I think the other one was probably like 25, 30 articles long between the ones that we read on the accessions list. But it just goes to show you there's no separating our state from the history. Like we can't go into the future and deny the history of where we've come from. It's got to go hand in hand. History and law always works in tandem. This is from Wikipedia, but I'm referencing now, and this is just to tie in the Supremacy Clause in our Constitution and take a look at the Supremacy Clause in the United States Constitution and kind of the parallels between the two and what they say. So, Mister, if you would give us a reading from the top, Supremacy Clause.
Supremacy Clause. The Supremacy Clause of the Constitution of the United States, Article 6, Clause 2, establishes that the Constitution, federal laws made pursuant to it, and treaties made under its authority constitute the supreme law of the land, and this take priority over any conflicting state laws. It provides that state courts are bound by and state constitutions subordinate to the supreme law. However, federal statutes and treaties must be within the parameters of the Constitution. That is, they must be pursuant to the federal government's enumerated powers and not violate other constitutional limits on federal power, such as the Bill of Rights. A particular interest is the 10th Amendment of the United States Constitution, which states that the federal government has only those powers delegated to it by the Constitution. The Supremacy Clause is essentially a conflict of laws, rules specifying that certain federal acts take priority over any state acts that conflict with federal law. Some jurists further agree that the clause also nullifies federal law that is in conflict with the Constitution, although this is disputed. The Supremacy Clause follows Article 13 of the Articles of Confederation, the predecessor of the Constitution, which provided that every state shall abide by the determination of the Congress on all questions which by this confederation are submitted to them. As a constitutional provision announcing the supremacy of federal law, the Supremacy Clause assumes the underlying priority of federal authority, albeit only when the authority is expressed in the Constitution itself. No matter what the federal or state governments might wish to do, they must stay within the boundaries of the Constitution. Consequently, the Supremacy Clause is considered a cornerstone of the United States federal political structure. The Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or the laws of any state to the contrary notwithstanding.
Okay. And I'm pointing this out as a corollary. Okay.
Mm-hmm.
This is not our Constitution.
No.
But what it does say is this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States. So our treaty is what, 1787?
Our treaty is for the United States, not of the United States.
I'm talking about the Treaty of Peace and Friendship.
Oh, yeah, 1786.
Okay. So that law supersedes this Constitution because the United States is bound by all laws that are made or all treaties made or which shall be made under the authority of the United States.
Mm-hmm.
So moreover, all the accession documents that the United States signed are the treaties
Supreme
which
law.
shall be made.
Right.
So those international laws that we're talking about, those accessions that we're talking about, supersede this Constitution. It says right here.
True.
It's their supremacy clause.
Right.
So again, we're playing by the same rules in our Constitution, but I'm just giving you the corollary between our document and their document.
True peace. No,
and
it makes
why
sense.
It was built in such a way by Gabonde Waseka. Okay?
Right. True peace.
So this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, which we know 1787 was a predecessor, or which shall be made, are all the accession documents that the United States had to accede to be a member of the United Nations.
Mm-hmm.
Excuse me. So all those Organization of American States, United Nations, all those international bodies,
Right.
they made accessions to, and those laws supersede the Constitution.
Right.
Okay. So this is what I'm talking about as far as receipts. So when you have the receipts from all these other organizations, you can hold their feet to the fire.
Right.
Because no, your Constitution is not the end all be all. It says right here that you acceded to these other treaties. Those other treaties, declarations, and conventions supersede this federal law.
True peace.
And we can use that to hold you to the fire, to take you to court,
they still
to prosecute you
still
for the wrongs of against the indigenous autochthonous Moors.
Indeed.
Right?
True peace.
Those are the receipts that we're using. Okay, so this is 1514, General Assembly Resolution 1514, adopted December 1960. And we're going to do a quick read of this one because it's fairly compact. Fairly compact read that we can get out the way and get an understanding of the greater message. So if you want to go ahead and start at the General Assembly.
The General Assembly, mindful of the determination proclaimed by the peoples of the world in the Charter of the United Nations to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women and of nations large and small, and to promote social progress and better standards of life in larger freedom. Conscious of the need for the creation of conditions of stability and well-being and peaceful and friendly relations based on respect for the principles of legal rights and equal rights and self-determination of all peoples, and of universal respect for and observance of human rights and fundamental freedoms for all without distinction as to race, sex, language, or religion.
Pause there. Conscious of the need for the creation of conditions of stability and well-being and peaceful and friendly relations based on respect for the principles of equal rights and self-determination, right? Self-determination is what Moors pride ourselves on, right? As individual Moors,
right,
and as states, as newly formed states in varying degrees of advancement. Self-determination of all peoples in the universal respect and observance of human rights and fundamental freedoms for all without distinction as to race, sex, language, or religion. Go ahead and pick up at recognizing the passionate
yearning for freedom in all dependent peoples, and the decisive role of such peoples in the attainment of their independence. Aware of the increasing conflicts resulting from the denial of or impediments in the way of the freedom of such peoples, which constitute a serious threat to world peace. Considering the important role of the United Nations in assisting the movement of independence in trust and non-self-governing territories, recognizing that the peoples of the world ardently desire the end of colonialism and all its manifestations.
Pause there. So in Allodium Moorish Parade, Monte Colorado's application to the United Nations, considering the important role of the United Nations in assisting our state in the movement for our independence in a trust territory and non-self-governing territories. So they're talking directly to us.
Right.
I mean, you have to break down the language, but what they're saying directly relates to what we're currently engaged in as a state and the varying degrees of advancement that we're going through to try to gain our independence from the corporation U.S., correct?
Correct.
Okay.
Convinced that the continued existence of colonialism prevents the development of international economic cooperation, impedes the social, cultural, and economic development of dependent peoples, and militates against the United Nations ideal of universal peace. Affirming that peoples may, for their own ends, freely dispose of their natural wealth and resources without prejudice to any obligations arising out of the international economic cooperation based upon the principles of mutual benefit and international law. Believing that the process of liberation is irresistible and irreversible, and that in order to avoid serious crisis, an end must be put to colonialism and all practices of segregation and discrimination associated therewith. Welcoming the emergence of recent years of a large number of dependent territories into freedom and independence, and recognizing increasingly powerful trends towards freedom in such territories which have not yet attained independence. Convinced that all peoples have an inalienable right to complete freedom and the exercise of their sovereignty and the integrity of their national territory, solemnly proclaims the necessity of bringing to a speedy and unconditional and colonialism in all forms and manifestations.
Pause. Convinced that all peoples have an inalienable right to freedom, the exercise of their sovereignty, and the integrity of their national territory, solemnly proclaims the necessity of bringing to a speedy and unconditional end colonialism in all its forms and manifestations, and to this end declares that one, go ahead with one.
The subjection of peoples to alien subjugation, domination, and exploitation constitutes a denial of fundamental human rights, is contrary to the Charter of the United Nations, and is an impediment to the promotion of world peace and cooperation. 2, all peoples have the right to self-determination by virtue of that right. They freely determine their political status and freely pursue their economic, social, and cultural development. 3, inadequacy of political, economic, and social or educational preparedness should never serve as a pretext for delaying independence.
Pause there. Inadequacy of political, economic, social, or educational preparedness should never serve as a pretext for delaying independence. What does that mean to you?
If the people aren't that educated, that don't mean they still can't be free and independent. So I guess they're saying inadequacy of political, economic, social, and educational preparedness.
So as it directly relates to us and our purposes, states in varying degrees of advancement, right?
Right.
So the inadequacy of political, economic, social, or educational preparedness. So states in varying degrees of advancement, some have a lot of erudition, a lot of individuals that are very competent. Some have a few individuals that are competent. And some are just, again, forming and getting their conscience together and moving towards the trend that, yes, we do need to form a state. 3 right here says inadequacy of political, economic, social, or educational preparedness should never serve as a pretext for delaying independence. And this is United Nations talking in its 1514 document. But they can't delay our independence because we're not
ready
as prepared as they are, and they have had a 200-year head start. Right?
Mm-hmm.
4.
All armed action or repressive measures of all kinds directed against dependent peoples shall cease in order to enable them to exercise peacefully and freely their right to complete independence, and the integrity of their national territory shall be respected.
Okay, pause. Mister.
Yes, sir. Yes, sir.
Give me an interpretation of Article 4.
Basically, code enforcers, all armed action. So that's how I look at it. The only lawful man on the land would be U.S. Marshal or the sheriff. So people like code enforcers, police officers.
That's exactly what I was thinking. All armed action or repressive measures of all kinds directed against dependent peoples shall cease in order to enable them to exercise peacefully and freely their right to complete independence, and the integrity of their national territory shall be respected.
Islam.
So we've claimed our jurisdiction under Udi Pasade's juris, correct?
True peace.
All armed action or repressive measures of all kinds directed against our state and the nationals of ANPAC shall cease in order to enable us to exercise peacefully and freely our sovereign right to complete independence and the integrity of our national territory, our Udi Pasade's juris territory that we claim,
True peace,
shall be respected. Now, this is a receipt, right? So anytime that we have a problem with, governor, state attorney, secretary general, we're going to do what?
show them a receipt.
We're going to show them a receipt and remind them that under 1514, it's against the law. It's against international law.
Right.
Not your chartered colony state law, not your U.S.
Right.
federal law, but international law.
True peace.
That's pressure.
True peace.
Okay.
True peace.
5.
Immediate steps shall be taken in trust and non-self-governing territories of all other territories which have not yet attained independence, a transfer of all powers to the peoples of those territories without any conditions or reservations in accordance with their freely expressed will and desire, without any distinction as to race, creed, or color, in order to enable them to enjoy complete independence and freedom.
Okay, Owen, pause there. Give me an interpretation of Article 5.
Well, in trust and non-trust territories, power should be transmitted or given over to the people without any hesitation, without anything. Power should be handed over to the people.
Okay. But what this is saying to me, and more importantly, immediate steps shall be taken, so they need to work with us as a state. In trust and non-self-governing territories, or all of the territories which have not yet attained independence, to transfer all power to the peoples of those territories without any conditions. So, to me, that says no contracts.
Yeah, no conditions.
Right? Yeah. Because we're working off the original agreement of all the treaties, right? 1787, 1836, mm-hmm. and all the accession documents. So there's already documentation to govern what should happen and how things should be handled. There's no need for any additional documentation. They can't indemnify themselves against anything, right? They need to be taking immediate steps to hand our power, our land, our resources, our mineral wealth, and our estate trust back over to the jurisdictions that have ratified, promulgated, and are acceding to all the treaties, declarations, and conventions in accordance with all the international laws. Right? Let's go to 6.
Any attempt aimed at the partial or total disruption of the national unity and the territorial integrity of a country is incompatible with the purposes of principles of the Charter of the United Nations. All states shall observe faithfully and strictly the provisions of the Charter of the United Nations, the Universal Declaration of Human Rights, and the present declaration on the basis of equality, non-interference in the international affairs of all states.
The internal affairs.
Internal affairs of all states, and respect for the sovereign rights of all peoples and their territorial integrity.
Okay. And as a recap, 7, all states, meaning international states and even Moorish states, shall observe faithfully and strictly the provisions of the Charter of the United Nations, the Universal Declarations of Human Rights, and the present declaration on the basis of equality, non-interference in the internal affairs of all states, and respect for the sovereign rights of peoples and their territorial integrity. So meaning what?
Meaning that that we all these the Declaration of Human Rights, Declaration basis on equality, international affairs of the United States.
Basically just telling them that ain't no breaking up or division amongst the people, because it doesn't. It's going to go against international law if you're going to do that. It's going to be a problem.
But moreover, I want you to look at non-interference in the internal affairs of all states. So that precludes even Allodium, Moorish, Paredia, Monte, Colorado from interfering in the internal affairs of
The United States.
Maru, Anta, Georgia,
Right.
New Mecca, Unami, Buffalo Nation, because we acceded to this, right? So we will be violating our, accession by interfering in the internal affairs of any other state.
Any other state.
And that's what I'm saying. We've got to be mindful of what we've put on record, right?
What you acceded to, what you agreed to.
Right. Because then they have recourse. They can say, okay, well, we see that you did A, B, C, and D. However, in your zeal to, push a narrative, you violated your treaty accession. So as a consequence, we don't necessarily have to recognize you. We don't necessarily have to give you non-member status. We may require that you do something else. But again, this is built into everything that we put in place. And we can't ignore something because we're not aware of it, because what?
Ignorance to the law.
Ignorance to the law is no excuse. Right?
Right.
Because we're not playing on a club level or an organizational level. We're playing on an international level. Right?
So this is saying basically everybody's got to respect everybody and stay out of everybody's business.
Correct.
I can't go in your backyard and start doing something. You
At
know?
all.
Yeah. I get that.
I have to respect your politics. I have to respect that you'll resolve whatever it is that you need to resolve on your own. Just like the United Corporation has to respect that we're going to take care of our business and they can't interfere one way or the other, or they're going to be in violation of the accession. It goes both ways. I just want to recap and just have you understand the accession documents are here on our website, gov-ampac.org, which is gov-ampac.org. Our Constitution, the accession documents, your path to nationality, should you choose to take that path. A foreign relations documents for all the states that are forming that may or may not have a checklist. Public notices of any laws that we may have on the books, or public notice for any public notices for anything that's going on in the jurisdiction of AMPAC that directly affects the nationals. And the last tab is bills and laws for things that are going to be debated by our Legislative Council, the Aziz. So again, those are some of the resources that are available to you. It is our website available 24 hours a day, 365 days a week. I'd like to thank you again for tuning in, and to our readers, Brother Owen Bay and Mr. Want to compel you again to please study, and Islam.